Namaskar and good afternoon to all. Now, delivering a keynote address on a topic about which I do not claim to be having much of knowledge, what to say about being an expert, that too in the presence of the legal luminaries of the field, doyens of the bar, is a nothing but, intimidating experience for me. So with this caveat, I would only say that, IPR is one of the emerging areas and most expanding areas of law to be administered through courts. So therefore, the importance of IPD in Delhi and other places of the country. I feel very happy to be present amongst all of you, not because I am supposed to deliver a keynote address, but because I am getting an opportunity to learn. Traditionally, judges have always been learning from the lawyers. We call the lawyers learned counsel. The judges are not learned. They are, of course, honorable. But it is the lawyers who are learned. So this opportunity which has been given to me, I take it as an opportunity to learn something about the legal issues which will be discussed in today's symposium. Job of a judge and job of a lawyer, these are very two different ball games. If anybody from my family or any of my acquaintance or friend comes to me with some kind of a legal problem, I'll say, sir, I've stopped advising as a lawyer. I'll refer him to go to some other lawyer and get a better advice. So that's the difference of approach. So our jobs are different, but I'm again express my happiness to be here and to enjoy the opportunity of learning from all of you. When this idea was mooted by Justice Tushar and Justice Jyoti Singh, I insisted that such kind of a symposium should be well attended by the lawyers, not only amongst the listeners, but also amongst those who will be speaking. And I am very happy that the symposium has been organized in a manner which is going to be a great learning experience to all of us. Before I begin with my written address, may I ask all participants sitting here below 40, how many of you have ever read or even flipped through the pages of Mogha's Pleadings and Conveyancers? Please raise your hands. Below 40, Mogha's Pleadings and Conveyancer. So here lies the problem, perhaps. Perhaps here lies the problem. I would only say one thing, that what I have been taught by my teachers, by my seniors at the bar, and my own senior in the chamber, just one principle I would be stating, that pleadings should contain facts and facts alone. That's the first principle, that's a rudimentary principle of pleadings, which should be borne in mind by all young lawyers. And I would again suggest, I don't know whether Mogha's Pleadings is out of print or not, but it must be available in our library. So you should go read it, at least flip through those pages, and you learn a lot about pleadings. I come to the written address. So my esteemed brother and sister judges, learned President of the Bar Association, Mr. Hariharan, the members of the Executive Committee of the Bar Association, senior advocates, members of the bar, officers of the registry, ladies and gentlemen. It has been increasingly observed that the pleadings filed in matters instituted on original side of the court means this court, are becoming excessively lengthy and voluminous. We are competing perhaps with Bombay now. Mr. Mehta will bear a testimony to it. In several cases, the plaint itself extends beyond 500 pages, and in some instances, even the interim applications seeking urgent or ad interim reliefs are comparable volume. Such extensive pleadings are no longer an exception but have become a growing practice in commercial suits and matters pertaining to intellectual property division. This trend has given rise to serious practical and procedural difficulties affecting not only the registry and the litigating parties, but also the effective functioning of the court. It is a settled principle of procedural law that pleadings are required to contain only material facts constituting the cause of action, the defense in concise form as contemplated under Order 6 of the Code of Civil Procedure. However, contrary to the spirit and mandate of the said provision, pleadings are increasingly being converted into elaborate narratives incorporating unnecessary details, lengthy factual descriptions, extensive extracts from statutes, and verbatim reproduction of judicial precedents and repetition. Instead of confining themselves to the essential facts and legal grounds necessary for adjudication, parties often attempt to place every conceivable aspect before the court in exhaustive detail, resulting in pleadings of unwarranted length. The issue becomes more serious in commercial disputes and IPD matters, where the parties frequently reproduce substantial portions of enactments such as the Trademarks Act, Copyright Act, Design Act, Patents Act, and in addition thereto, entire passages from judgments of Supreme Court of India and various high courts are also being often quoted verbatim in the pleadings. Such reproductions unnecessarily inflate the size of the paperwork and do not materially advance the adjudication process. The court is already well acquainted with the applicable law. That's at least we can claim, we don't know, and judicial precedents, and therefore extensive quotations from statutory provisions and judgments in the pleadings themselves serve little practical purpose. At best, only the relevant portion of law or brief reference to the relied upon judgment may suffice. The filing system having now substantially transited to electronic mode, with physical filing being minimal or almost non-existent, the practical difficulties arising from voluminous pleadings have multiplied considerably. The registry, particularly the filing counter, and the scrutinizing branches are required to examine every page of the pleadings and accompanying documents to ensure compliance with the procedural requirements. Scrutiny of thousands of pages in a single matter consumes an enormous amount of time and administrative resources. The process becomes even more cumbersome when repetitive pleadings, overlapping annexures, and avoidable reproductions are involved. I'll just narrate a very interesting anecdote. While I was in Bombay, a writ petition was filed. I mean, the law of pleadings is equally applicable to the writ petitions also. Not only it is not confined to suits. So, in a writ petition, one enclosure was annexed. It was a notification, gazette notification. So, generally the language of the high courts all through the country is English. So is the case with Bombay High Court. So that notification, the entire notification running into say 20, 30, 40 pages was enclosed. That notification contained not only Hindi version of the notification, not only English version of the notification, but also Marathi version of the notification. I could understand Bombay has, and the adjoining areas in Maharashtra, they are Marathi speaking people. So at the most, English and Marathi version would have sufficed. What was the need to enclose the Hindi version also? So that's the kind of, sometimes negligently, sometimes I don't know why, the pleadings are becoming voluminous more and more every day, which does not serve any purpose. It does not serve the cause of your client to whose cause you are espousing or trying to espouse before the court. The burden created by such lengthy pleadings is equally significant for the honorable judges. The judges are required to hear and adjudicate numerous matters on a daily basis. Unlike advocates, you'll not mind it, unlike advocates who may devote several days or even weeks in drafting a single matter, the judges are expected to study, understand, and hear multiple cases within a limited span of court hours. Reading extensive pleadings on computer screens for prolonged periods causes considerable strain and makes it extremely difficult to maintain the required degree of concentration throughout the day. In matters where each side files voluminous pleadings running into several thousand pages, the time required merely to identify the core controversy becomes disproportionately high. The problem does not end at the stage of pleadings alone. Since the pleadings themselves are extensive, the notes and compilations prepared for the court also becomes voluminous. During the course of hearing, substantial judicial time is spent in navigating repetitive averments, unnecessary details, and lengthy quotations, rather than addressing the real issues requiring adjudication. Consequently, after conclusion of arguments, the exercise of preparing a reasoned judgment also becomes more time-consuming. The court is then compelled to deal with numerous contentions, repetitive submissions, and extensive records, resulting in lengthy judgments consuming substantial judicial time and effort. This inevitably affects overall judicial efficiency and contributes to delay in disposal of matters. It is also important to note that unnecessary expansion of pleadings increases litigation costs for the litigants themselves. Preparation, compilation, indexing, and filing of such extensive pleadings require considerable professional time and financial expenditure. Litigants are ultimately burdened with avoidable costs without any corresponding benefit to the adjudication of the dispute. Precision and brevity in pleadings would therefore not only assist the court, but would also serve the interest of litigants by reducing cost and expenditure. The purpose of pleadings is to precisely identify the dispute between the parties and to inform the opposite side of the case it has to meet. Pleadings are not intended to become treatises on law or compilations of judgments. Material facts alone are required to be pleaded, while evidence, detailed arguments, and exhaustive legal discussions are matters to be addressed at the stage of evidence and final arguments. Unfortunately, the increasing tendency to include unnecessary details and repetitive averments has diluted the very object of pleadings as contemplated under the law. In many cases, it is observed that written statement reproduces each and every averment of the plaintiff in great detail before providing a response. Thereafter, lengthy preliminary objections covering numerous pages are inserted even where many of such objections may not be germane to the actual controversy. Similarly, replies to interim applications and replications, rejoinders, again reiterate the same facts, submissions, and legal propositions already stated earlier. By the time the pleadings are completed, the size of record often becomes 3 to 4 times larger than the original paper book. Such repetitive pleadings unnecessarily complicate the record and make identification of the actual issues more difficult. The present situation, therefore, necessitates serious deliberation and corrective measures to ensure that pleadings on the original side are concise, precise, and confined strictly to material particulars. The need of the hour is to revive and enforce the true spirit of Order 6 of the Code of Civil Procedure, which mandates concise pleadings. Courts across jurisdictions have repeatedly emphasized that brevity and clarity are hallmarks of effective pleadings. A well-drafted case can often be effectively presented within a limited number of pages if the focus remains on the material facts and essential issues. It is therefore considered necessary that members of the bar, particularly those practicing in commercial and intellectual property matters, collectively undertake efforts to discourage unnecessary prolixity in the pleadings. The learned members of the bar and stalwarts in the field of intellectual property rights may take the lead in evolving better drafting practices and professional standards so as to ensure that future filing on the original side do not contain avoidable repetition, excessive quotations from statutes, or verbatim reproduction of judgments. Concise and focused pleadings would not only save precious judicial time, but would also facilitate more efficient and meaningful adjudication of disputes. The issue is of considerable importance to the administration of justice and deserves thoughtful consideration by all stakeholders. If appropriate measures are adopted and the discipline of precise drafting is encouraged, it may significantly reduce unnecessary bulk in court records, improve efficiency in judicial functioning, and ultimately serve the larger interests of justice and the litigating public. Before convey my thanks again, I would just urge with the younger lawyers, the budding lawyers, to go through Mogha's pleadings once again. Thank you. Thank you so much.